Okay, good morning again, everyone. My name is Liz Garcia. I am founder of the Mind, Body, Spirit Network, and I host this weekly online meetup group so that we can all come together to network, collaborate, and really learn some key topics in regards to marketing your business, growing your business, the legal side of business, etc. And today we have a special guest who is, I'm going to read her bio. Hold on. When I first met Adrienne, I'm like, I want her at my meetup. I want her to talk. And then when I saw her bio, that was exactly why I wanted her. I'm like, because she's scrappy. I love that. So hold on. So, all right. Adrienne Fischer is a small but scrappy startup attorney in Denver. And in case you guys don't know, Denver is startup heaven. It's like probably #1 startup cities in the country now, isn't it, Adrienne?
Yes.
Wouldn't you say? I mean, it's huge. I mean, Denver Startup Week is coming up, isn't it?
September.
Oh, it's September. Never mind. It already came and went. But do you present there at the Denver Startup Week?
I'm an advisor for the Commons on Champa during Startup Week. So I advise, I have office hours and try to help entrepreneurs on the fly.
Awesome.
Trying to do an actual presentation this year.
Oh, cool. That's fantastic. All right. Well, so Startup Week, if you guys are into startups, venture capital, the whole lot-de-do, this is where you come to do it. All right. So Adrienne creates quality, affordable, and comprehensive legal solutions to help her clients reach their peak. She works with small businesses, startups, and entrepreneurs. Adrienne has represented small businesses, the most populous county in the United States. That must be in California, huh, Adrienne?
Mm-hmm.
What was that?
LA?
LA?
I represent, Los Angeles County.
Oh, that's a lot going on there. Okay. And okay, so the most populous county in the U.S. and an up-and-coming media company. Can you tell us who that is? Or is that private?
Sure. I worked for Machinima Inc. and I started my legal career as in the entertainment industry, actually.
Oh.
And, I worked at NBC Universal during law school. So.
Oh, cool. All righty. Okay, so she's mediated cases in some of the busiest courthouses in the U.S. She handles contracts, employment law, business law, and trademarks. She also does conscious contracting for business partners. And when she's not working, she's outside somewhere skiing, hiking, or rock climbing, and that's what we do here in Colorado. In fact, I went on a little hike with Miss Johanna not too long ago, which was a lot of fun. And if you want to find out more about Adrienne, you can see her at summitlawsolutions.com, and I will share that link in the chat with you guys. So, Adrienne, we're just going to do like a kind of a casual chat style, right? That's what you want to do? And if you have a question, would you like people to just raise their hand or put a question in the chat? What would you prefer?
You can raise your hand. I can take a peek.
Okay, cool. All right. So I just shared Adrienne's website, so you can connect with her later. And you have got the floor, my dear.
Thank you. I appreciate the introduction. So I deal, as Liz said, with small businesses, entrepreneurs, and startups pretty much on a daily basis. And one thing that I find is I get a lot of similar questions about trademarks. Most people want to know, what is it? You know, we kind of know in general, well, the bigger things that are trademark, like Coca-Cola, or you hear about infringement, but what is a trademark? So I'm just going to hop right into it. And if you have questions along the way, please don't be shy. I want this to be very casual and conversational. And I love helping people learn about this stuff. So it's fun for me. Legal nerd, I don't know. So So what is a trademark? Has anybody, does anybody here have a trademark?
No, I don't think so.
Okay, so a trademark is, it's essentially your brand. Most people are small businesses, entrepreneurs, or startups. They have a brand for a good or service. And the big ones I like to think of is like Nike. We all know the Nike symbol, the Nike logo, and the slogan, just do it. So you've got 3 trademarks in there. You've got Nike, the name, which is a word mark. You've got the swoosh, which is the check, the Olympic swoosh. And then you've got just do it. All 3 of those have been trademarked. And really what that does is it helps a consumer tell where that product is coming from, which is the whole reason why trademarks exist. So you want to know the point of origin for a good or service. And so the reason why it's important to register a trademark is you put basically everybody in the US, because I practice mainly in the US. Liz mentioned that Lisbeth is in Denmark, so that's a different system. You can still register goods in the US or a trademark in the US, but if you want something that's going to be protected abroad, then you might look into a lawyer who has experience with what's called the Madrid Protocol. So basically, when you register a trademark, you register it with the US Patent and Trademark Office, and you want to make sure that you put everybody in the US on notice that you're using this mark. So for example, I can talk about one that I've done recently. My parents started a coffee company. It's called Pour Coffee Company, P-O-U-R. Very, very exciting for them. I'm so excited they got into coffee.
That's awesome. How old are your parents?
They're in their 50s and 60s.
Wow, that's awesome.
This is their retirement dream.
Cool.
So we wanted to make sure that they had a sustainable mark that they could market, and they wanted something. Now, my concern is pour actually is a very descriptive term, because what do? You pour coffee. There's a spectrum of what's protectable with the USPTO. So the more fanciful and arbitrary your mark is, according to the USPTO, the higher level of protection you're going to receive. This is why Apple, because it has zero association with computers, is so heavily protected. Apple is registered across, I don't know, a crazy amount of classes, because when you register a mark, you also pick a class. So, for example, Apple registered their mark with the computer class, and also music, because they're into music and videos. An example of two competing marks that are in the same name but different classes. So let's take Delta Airlines. Delta Airlines registered their mark for protection with airplanes, but there's also Delta Faucets, and they can have the same name, but because they're not being marketed to the same people, they can register in different classes. So you can have the same name as somebody else, but you can't confuse a customer. So you want to make sure that you do a very thorough search. So I have access to software, which when I run a search, which is the first step of really, first step, you gotta have a name, a logo, or a slogan. But really the first step on that course to getting a trademark is conducting a clearance search. And I have access to software where I put in your name, and it checks not just the federal registry or the USPTO, but also the state registries to see if anybody's running a corporation, and then also the social media, and also the world, really. So that's the first step on the track to getting a trademark. It's number one step. And then what happens next is I write an opinion letter. So I look at the search results, and we go through them, and I say, okay, well, there's a Pour Coffee Company. So there's P-O-O-R Coffee Company. Is that going to be confusing? So we kind of look at all the different results and see where people, maybe they haven't registered yet. And if you haven't registered, it's like you have some protection. Oh, Cheryl, do you have a question? Okay. So yeah, if you haven't registered, you have some common law protections if you are using a name in commerce. But really it's he who registers wins.
You mean registering the actual trademark?
Yep. So if you're using a name, the word mark, and you're using it in commerce, and let's say somebody else beats you to registration, they're going to have, and they register before you do. This happened to actually one of my clients, and we're still working on it. So she has a company that she's been using this name now since 2011. Somebody else actually has the same name in the same services, and they registered before her in 2008, and they're not even really like using the name so much. And so we're trying to get her into the system as with that name, but we may just have to negotiate, the company's in Canada, she's in the US, maybe we're going to agree that we can both have the name and kind of they're not going to sue her for infringement.
So if they're in Canada, don't they have their own trademark, or the Canadian used the trademark in the US? Is that what you're saying?
Yeah, so they claim that they sell their product in the US, and then they had an attorney register it here in the US.
Okay.
So you can definitely register a trademark if you're in another country conducting business in the US, you can definitely register here. You don't have to be a citizen.
Okay. I do have a quick question.
Mm-hmm.
So I always register my trade name with the state every year, right? You have to register your company. Does that still doesn't has it have any bearing or not really?
So trade names are great for protection in the state that you're in. So nobody in Colorado, like you registered a trade name, technically you have the upper hand. They don't really provide that much protection.
Okay.
But basically nobody can use the exact name as typed out on the trade name and on your articles of organization. So the Secretary of State provides some level of protection, but the federal level is really for people who want to take it to the next level, because the protections provided is not only can they not register your name as it's spelled out exactly, but if they have a federal trademark, the trademark office is going to prevent people from registering, let's say your name, Mind, Body, Spirit Network had like a misspelling in it. Like they took out like something to denote the mind, or they abbreviate it somehow. The trademark office would say, hold up, we've got a registered mark that looks like that, and it's going to confuse customers, particularly if you're in the same business or class.
Okay, and then what about domain names? Is that what you were talking about when you're searching social media? Or,
yes.
Web, Facebook pages and stuff like that?
Yes. So it's great if you have them. They provide absolutely zero protection.
Okay. So the only leverage you have is if someone trademarks your domain and then they want your domain and then you sell it to them for $1 million.
Yeah.
Right.
If you've got a really good domain, you can sell it to, they're transferable, and trademarks are actually transferable as well. So if you register a name that's somebody, they're a digital asset, or they're an asset essentially that can be transferred. You can transfer like a title to a car.
Okay, cool. I didn't know that. That's good to know. Mm-hmm. Yeah, of course, if you're going to sell a business, you're going to sell all the assets with that business. Okay.
Right.
All right, cool.
Deborah, you have a question?
Yeah, if you, with the domain name, because when I was looking for my domain name, someone had snatched up the name for my company, and they're just sitting there with that name and saying it's for sale, which I don't even see how that happened. But if I register my company name, would they then still have the same leverage with that trademark? With that domain name?
You may just tell them that you want it that much more now that you've spent money to register a trademark with the domain name, right? So if they're not using it, one thing that has to happen for a trademark to take effect is you have to prove to the USPTO that the mark's being used in commerce. So you have to be using it to make money. So with your specific question, there are cyber squatters out there. I'm so sorry. I know it's very hard to come up with a domain name these days. Names are very difficult. You have to be even more creative than ever before when naming a business. And so, the best you can do is make offers and see if they'll sell it to you for a price. But I always tell my clients, have probably 3 names that you like, because we may have to change them.
Yeah. Okay. All right. Thank you.
On that same note, I went to a networking event or a speaker event in Aspen, Colorado, where there's a lot of billionaires. Mm-hmm. And there was this, it was a startup event. And one of the speakers was this ridiculously arrogant, someone I don't even want to say, but he made millions of dollars as a cyber squatter. He got in on that deal fast, and he made boatloads of money, and he likes to show it off. So they exist. Sorry, Deborah. You guys could be cyber squatters too. You come up with a good name, go buy it. Although if it's really unique, someone really unique needs to use it. So anyway. All right, so good to know the domain name means nothing unless someone really wants to trademark it, and then you could sell it. That's probably the only leverage there, right?
Yeah, you can definitely, you can sell domain names. I'm sitting on a couple that I plan to use maybe in the future. I just did it now as future thinking. So I think that's helpful. If you know you want a name, doing the research before you even talk to a lawyer. But, for small businesses and entrepreneurs, I always have this conversation. Trademarks are expensive. They're like an expensive puppy to get. You have to put up a lot of fees to do the search, to pay the attorney, to do the trademark. It's $275 a class with the USPTO. So let's say I had a client who needed to register with 3 classes, 275 times 3. That adds up really quickly for a small business.
That's just for the registration. That's not for your work.
Oh no, that's not for my work. That's
okay.
To put it on the.
Gotta make sure people hear that. Okay.
Yeah. So I always tell people, it really, yes, it matters. If you're using it in commerce and you're using it, so you're pushing out product, you have a website with an e-commerce portion. You've got, t-shirts with your slogan. You've got, and you're making money off of it. You've got, you're pushing through services, and you're making money off of this name. That's when it becomes important to trademark it, because otherwise, why are you going to spend the money to trademark something you're not making money off of yet? Sometimes people come to me and they're like, well, I just started my business. I'm like, but are you making money? Because in 6 months, you may hate the name.
And the business.
And the business.
Right.
So there's a lot, and there's a limit to what can be trademarked as well. I see people trying to capitalize, like on the Me Too movement. Somebody tried to capitalize #MeToo, and boy, oh boy, did they get shut down by both the public and the USPTO probably would have said no. So yeah,
that's an interesting thing.
Yeah.
Cyber squatter, right? It's like a cyber squatter. Oh, I want to make money off of this. Was it a guy?
I'm trying to remember who it was. Yeah, there were a couple, where they were trying to do trademarks on She Persisted and all the political stuff that has been coming out lately. And it's just like, no, don't do it.
Okay.
So, and then, in the search process, after the search process and the opinion letter is done, basically you get a green light from me that we're going to proceed. Then we fill out the application. That's where we pick your services or your goods. And like I said, trademarks can be applied to both goods or services. So if you're selling essential oils under your brand, or I'm trying to think of mind, body, spirit alignments of what I've seen, or lotions, or you've got some type of, you sell, maybe you do a rose quartz with your brand engraved, I don't know. Then, you may think about trademarking those items, those specific categories of items that you're selling, because you're selling, and t-shirts and mugs and all that. Apparel has its own class, hats, jewelry. Basically anything you can think of, there's probably a class for it.
So you'd actually trademark the use of a logo, for example, on a mug would be a different class than a logo on a wearable item.
Correct.
So you're protecting your ability to use that so no one else can do it.
Right.
Essentially. Okay. Oh, I can see how that could really get expensive. I'm sure Nike does it all, of course. Everything that they trademark, label is all trademarked. Okay. All right. That's good to know. Okay. Thank you.
Sure. And then let's see. After we do the application, another thing that people don't know is that it takes 9 months to a year. It takes 3 months for a trademark attorney to even be assigned to your application. The USPTO is that backed up. So,
whoa!
Yeah.
Okay. It's 9 months to a year. It's like having a baby.
Yeah, really. Like everything with your
without
business.
all the fun. Or not.
So,
for me.
so yeah, it's not a slow, it's not a quick process. It's not cheap. It's like, yeah, it's like getting a puppy and then waiting 9 months to see if it actually, arrives. Cause I don't know, you see a picture on the internet and you've got to go find the puppy and pay for it up front.
All right. So you're going to go through the process and you may, in the first step, find that it's not doable.
Correct. Yep. So the way I try to do it is I try to break up the fee for the search and the opinion letter, because we may just stop after the search. Right. And that's and that's actually another point that I like to bring up. A lot of people say, well, LegalZoom. And I'm like, okay, document preparation companies. You can do this on a document preparation company website, and people do it, and sometimes they're fine. They fill out the application themselves. But what LegalZoom doesn't do, I keep saying that, document preparation companies don't do, is they don't, unless you elect to pay more, they don't do the search. They don't do the due diligence part. They're just merely putting what you say onto an application. And so those applications, I think there was a stat out there that with an attorney, you're 50% more likely to make it through the process without an office action. So, yeah, they don't do the due diligence side. They don't do the search. They don't even counsel you as to whether or not it's a good idea. So unless you pay their attorneys. So that's the difference between, going with a document preparation company. I'm not saying it does work out for some people, but I get that question a lot. Why is LegalZoom so cheap? Well, they're not doing the search. They're not talking to you about whether or not it's a good idea to trademark your mark, and maybe advising on what classes your trademark should be in. So maybe you pick the wrong class. So
that's good to know.
Yeah.
That was going to be one of my questions today, is to address that online document stuff. You get what you pay for. Pretty
much. And it's great for access. I mean, I'm all about access to legal services, so they do have their place.
Yeah.
And they are a service for people who, just need that service. So, but there are some differences with that access.
Yeah. All right.
And then I'm trying to think of other common questions that I get throughout the process. Is really timeline. Slogans are tough. They're doable. But, it's hard to come up with a really unique slogan these days that isn't taken. But to do the search and everything, those can be fun.
So a lot of people do trademark their slogans.
Mm-hmm.
And I would think that would be easier to do, but not necessarily.
It depends, because, for example, let's say you have a company that is using a slogan that like 6 people are using it in commerce. Then it's no longer unique. Trademarks give protection to uniqueness a lot of times. So If you're using something that just describes your services, there's no point in really trademarking your slogan. You're just describing what you do.
Okay.
Unless it's unique in some way. And, we can talk about what those specific slogans might look like. But if it's just a descriptive slogan, or it's being used in the market by a lot of different people and it's saturated and it's lost its uniqueness, that's when it becomes complicated.
Okay. So, and I would think also, if you use a piece of somebody's slogan in your own, like for Nike, what if I used "Just do it, you big dumb stoopy"? I mean, there would probably be legal protection for Nike for me not using that, wouldn't you think? Because they're so established with that trademark?
Yeah, to a certain extent. I definitely wouldn't use that slogan with shoes. But
right. Okay, right.
But yeah, it's kind of like copyright. The big thing with music is you can only use, I don't know, don't quote me on this, 7 to 9 bars of the same line of music without copyright infringement. And so, there's some, but it depends, again, class and, what you're going for, and how certain words, when you trademark a slogan, the trademark office will actually ask you to disclaim. So I'll just use my parents' example because it's easy. Is Pour Coffee Company. They said you can't have a trademark over the word company. I mean, that's just, you can't do that. So they'll ask you to disclaim, like, yes, other people can use company in their name.
I see what you're saying. So particular words are going to say, yeah, okay, I gotcha.
Yeah.
Right. And then I've noticed a lot of people that are packaging their services and trademarking that package, kind of like what Johanna was talking about, like a coaching system or a business system that she gives a unique name to. I've seen a lot of people trademarking that. Does that sound right? Or are people just throwing TM on stuff and thinking it's protected to look, more than they are?
People do throw TM on things that are often not protected all the time.
Yes.
So a coaching system may not fall. So usually trademarks are like they're a word mark. So it's the name of your company. It's a logo. You can actually search logos, which is crazy. But you can perform a search to make sure you're in compliance and not infringing on anybody else's logo. It's a slogan. You can actually trademark a smell. Haven't actually seen it done, but I know you can do it. I've heard of it. Really, a trademark is a brand. And if they can, I guess maybe, I haven't seen a coaching system where that would be trademarked. Usually that would be a copyright, which is something completely separate. It's a different office.
Okay. Well, it's the name of their system. So they're trademarking the name of the system, maybe not just the system, but the name of it, because it's kind of catchy.
Yeah. I've seen people do that, trademarking the name of a system. If it's part of their brand and they're selling that, as part of trademarks, again, protect brands. So but the actual system itself, like the pages of coaching, that would be something that falls more on the copyright spectrum.
Okay, so we brought up copyright earlier. Would you just give everyone a little heads up on copywriting and do you really need a lawyer for it is the question, and when would you advise someone to use a lawyer for copywriting purposes?
So copyright typically comes into play. It comes into play with works of authorship. And so works of authorship include music, plays, art, books. Those are things that typically fall more within the copyright spectrum than a trademark. It's a different office. It's actually very simple to copyright something. It's far less expensive. It's $35. And it's pretty navigable. You don't often need an attorney to do it. There are attorneys who do it for very, very little money. I just find that I'm like, if you have questions, feel free to ask, but you can go to Google Copyright Office, and it's really pretty straightforward.
Oh, cool. So even if, what's the deal with copywriting like a blog, for example, so people don't try to steal it?
So I would definitely, on your blog posts or on your websites, make sure that you have a copyright and the year. There are some levels of protection, like with trademarks, right? I should probably explain the different levels of protection of each. So copywriting, if you just put copyright year on your website or your blog, you're offered some protection. You're offered far more protection if you actually register the piece of work with the copyright office. And that just provides for more damages for you if somebody actually steals it.
Okay.
If you register it. So the protections have to do with the damages that flow back to you if somebody actually infringes on your work. And then trademarks, the different level of protection. Let's say that you have a product that is, that you push through, you have a product and it's too descriptive. So the trademark office said, trying to think of an example of a product. Oh, okay, I'll stick with coffee. So, the name Joe's Coffee House, Cup of Joe Coffee is too descriptive. Coffee is a cup of Joe. Everybody knows that. You're just describing coffee. That's not arbitrary. It's not fanciful. It's not really worth protecting. However, we're going to give you a little bit of protection. So we'll put you on the supplemental register. So there's the principal register, which if you get it on, the trademark office has deemed you to be to the level where you get that extra protection. So if anybody infringes, again, there's more damages, there's more fees for you. If you're on the supplemental register, you still put people on notice, but your mark is really just too descriptive for to be on the principal register.
Or too commonly used.
Correct.
Okay, so like Cup of Joe, like before coffee houses went nuts, I thought Cup of Joe was a great name for a coffee shop, you know, at the beginning when it all started.
Mm-hmm.
And I wonder if it would have been protected back then before it became such a, you know, a way of life.
You know, you might be right. Yeah, it's just, you know, if it's commonly used to describe something, then it's lost its uniqueness, and that uniqueness is what is protected. And then if you become like a famous mark like McDonald's, nobody can name their stuff McDonald's anymore, because you've reached that attainment of level of famous mark that they get a lot of high level protection. Or Apple, you know, you've reached that level of mark where, you know, nobody else can call themselves an Apple product. It's just, you can't.
No. You're going to jail and you can't afford to defend yourself.
Maybe not jail.
No, you went. Well, if you don't have money to pay damages, would you go to jail? What would be the consequences, I wonder?
Bankruptcy.
Oh, okay. Yeah, that would end it. Okay. Do you have more there, Adrienne, or can we ask questions?
Feel free to ask questions. That's pretty much the tail end. So, I could say the end of the process is, you know, we shake hands and throw a party when you get a certificate of registration. At the end of the process, you get a little certificate that says, I have a trademark.
Okay. Oh, cool. Well, that's fun. All right. I'm going to unmute everyone so everyone can talk. Claire O'Leary, welcome. You came in right at this. But we have it recorded so you can watch this later. So, Claire, do you know how to use Zoom?
Say that again?
Oh, now you know how to use Zoom. Have you used Zoom before? Okay.
I do. For whatever reason, I muted myself, then I got unmuted, and then I muted myself by accident. So.
Okay. Did you catch any of Adrienne's information here, or you just came in?
I just snuck in. I had a workout this morning, and
all right.
I was hoping to get here a little earlier.
Well, it's so nice to see you. Why don't you just real quickly, we have plenty of time. This is a networking group, and Claire is a former client of mine and good friend, and so happy to see you here today. Claire, could you just tell us who you are, what you do, and who you serve, and then answer the question, have you ever had to wish you had used a lawyer in the past? And the second question is, do you see yourself needing a lawyer for any particular reason in the foreseeable future for your business?
So, so if you've ever been in a situation or know someone who's been in a situation where they're sitting there having a conversation with their boss or with their husband, and you totally disagree with everything they're saying, but when you try to say something, your voice is stuck in your throat. You absolutely can't get a word out. It's like you're frozen. So I work with women who have been silenced for so long that they're unable to speak up for themselves. Most of the women I work with, but not all, have been are incest survivors. And I offer a program I call From Wounds to Wisdom that helps them through all of their old crap and back to having a voice again and into their own inner wisdom. So that's what I do. As far as a lawyer goes, I haven't actually gotten myself into a situation where where I felt like I wish I had had one. But I have thought about using one for trademarking. A couple of my things I call my process Pandora's Wisdom. And then I've got the Wounds to Wisdom that I'd also like to trademark. And funny thing, I've been using From Wounds to Wisdom for probably about a year now. And then, of course, our friend Oprah used it when she had her nice little speech a while back, so at the Golden Globes. So I was like, wait, that's mine. And I'm like, yeah, I got to do something. So hopefully it's not too late, but so that's what I'd like to use a lawyer for, as well as potentially set up a 1031 exchange so that I can get rid of my Denver house and buy one where I really want to live. That would be much more fun.
Where do you want to live?
Within a couple hours of my daughter, because I have a new grandbaby.
Oh.
So
Oh,
around Portland, but close to the water.
Oh, nice.
Liz, you are muted.
Liz, you're on mute.
You're muted.
My dogs were barking. I had to like make sure they didn't get on the recording. So Claire that brought up kind of an interesting situation. So she had a phrase in mind that then got used by Oprah. And no doubt this is now going to become a hashtag tweet, right? And now it's not usable possibly, right? Would you say?
I hope it's
I don't know if that's the case. It would depend on if Oprah decided to trademark the phrase. I mean, you're using it in commerce. That's the thing. You're making money off of it, which is what the trademark office really wants to see and cares about. So I would highly encourage you, if you do want to trademark that phrase, you know, we can do a search and see if it's being used already by anybody else. And that's really, you know, if you have a phrase that's really step one, is let's do a search to see who else is using it and in connection with what services, because it may be that your goods or services are different than where it's being used. So that's really, you know, we have to do a clearance search first before.
And Oprah wasn't necessarily using that for commerce at all.
Right.
Okay, so that's
I don't think she uses it as anything for business or anything like that. She just happened to use my words that I've been touting for a year and a half.
Okay, well, you're using them in commerce now, Claire, so you have a little bit of a leg to stand on there, possibly.
Oh, good.
Yes.
I hope so.
So we'll see. I have to say, you know, everything said on this video as a disclaimer, marginal legal advice.
Thank you, attorney.
Attorney. So, you know, I'm not your attorney. I'm not representing you. I'm just answering questions.
Oh, okay, good girl.
I have a signed engagement letter.
Yes, and thank you for answering those.
Sorry, we will not hold you accountable for any of this. Does everyone hold up their hand? We will not hold Adrienne accountable for anything she says here. There we go. Nice. All right, go ahead.
I have a question when I can about trademark and copyrights. Are there like yearly renewals, or are they trademark for a certain amount of time, like 10 years, or what's the length of these things?
So trademark renewal periods come up every 5 years.
Okay.
And copyrights, I can't think of off the top of my head, but I'm happy to answer. I'm happy to find out and get you to answer.
Just curious if what that was all about.
Yeah.
Okay.
So there's a renewal. You just have to show that you're still using it essentially in commerce.
So will you get some notification from the office saying, hey, your renewal's up, answer these questions, or do you need to engage a lawyer again, or it's just a simple renewal process?
The attorneys usually take care of the renewals.
Oh, okay.
Yeah, it's a fee, but every 5 years, your attorney will basically say, hey, are you still using this? And, or if you're the person that registered it, you'll get that notice. But yeah, it just depends on who you want to take care of it.
So Adrienne, when people hire, what's some good advice to give people? What should you look for in a good business lawyer, would you say? And it's specifically a trademark lawyer too. Let's deal with that first. And then in general, how would you advise people to search for a lawyer?
Yeah, I do get this question a lot. A good business attorney will kind of give you, sometimes you have to pay for a consultation. Sometimes you don't. A good attorney will either give you at least 20 to 30 minutes for free, or if they do make you pay for a consultation, maybe they might include it on a later, like put it towards the services when you retain them, because you're really just paying for their time. And then you want to make sure that they are knowledgeable on your subject. You can ask questions. Have they done this before? You know, how much experience do they have? What are some favorable outcomes that they've gotten for clients? You want to be sure, you know, nowadays everybody can write a testimonial. So you want to
not be sued for it.
You can vet them a bit more. And really, you know, it's really about how you connect with your attorney and whether or not they're responsive. You know, are they emailing you back promptly? You know, most attorneys, I try to have a sundown rule. So unless I'm on vacation, you know, respond within the next business day. But we all get those weeks where we get crazy and, you know, it doesn't happen. But generally an attorney will be responsive. And you want to make sure that, and I always tell people, shop around, you know, don't just talk to me. It's like going to a doctor. I might not have the answers that you want, or, well, sometimes it's good that I don't have the answers that you want, but it's good to get, you know, opinions. However, once you hire an attorney, do not talk to other attorneys about the opinions that your attorney is given. You've selected that attorney, and attorneys a lot of times don't like to, you know, take somebody else's opinion because maybe they don't have the full picture. So once you hire an attorney, you've kind of made that selection. But in the meantime, it's like a doctor. Shop around.
So what would you say about you besides, I mean, you're clearly scrappy, and that's why I had you on here. What do people love about you? Which I'm telling you, I'm just met her. I'm like, she's it. She's it. Is there something that you would like to contribute about what you do that's unique, or?
I really just I love working with small businesses and startups. I think being in this sphere has allowed me to transform my practice, particularly since I'm on my own, in a way that I never anticipated. And I've been able to work with clients and really achieve I love being solutions oriented, and I've been able to work with clients and really achieve some great goals. So I will say, you know, you take the wins, and sometimes you just got to figure out, you know, okay, well, maybe this didn't go the way we wanted it to, but what can we do now to move it forward and keep going? Or, you know, sometimes you have to come to a point where you can say, okay, let's just say you've tried everything that I can think of out of the box, and, you know, maybe this is just not meant to be. So sometimes I think having those conversations with clients and being honest, I'm pretty honest and upfront. If I don't think you have a good contract, case, mark, I'm not going to tell you to waste money trademarking something that's not trademarkable. And having those conversations, I think, is very important. Just being open.
Cool. I did have another question. What's the deal with the R with the circle versus the TM? What's the difference?
So the R stands for registered trademark. When you actually are in the process of getting a trademark, so you've applied, you can use SM or TM.
Oh.
Your mark to show that you're in the process.
What does SM mean?
Service mark.
Oh.
So there's a difference between trademarks and service mark. I'm just going to make sure that I got that right. I'm pretty sure. Yeah. Yeah. TM means that the mark is not registered. Usually they do, means you're claiming, you're claiming, but they're not registered. Okay,
so until you get that R, now what if someone uses the R and they're just using it illegally? Is that illegal to use it when you're not really registered? Because people do it all the time. I see it everywhere.
I think people do it all the time. If you own the mark, so trademarks are a negative right? So it's on you to enforce that nobody else used the mark. So that's why cease and desist letters are often written, is because they're enforcing their right to be the only person to use the mark.
Okay.
Trademarks, the trademark office gives you a right to tell other people, hey, you can't use that mark.
Okay. But registered is a sign that you're registered, it's done. I didn't know that difference. That's good to know. Mm-hmm. Well, we just have a few more minutes here. Does anyone else have questions? We've got this brilliant lawyer here to help us. Attorney, sorry. Do you prefer to be called attorneys, you guys? Doesn't matter.
You're one. Lawyer kind of has that.
You're listed in the yellow pages as attorneys, I noticed.
I can actually just speak to one more thing that comes up with trademarks is office actions. So let's say you've gone through the point, you've done the search, we've done the application. Sometimes if the trademark office needs clarification or they're saying there's a problem with the registration, you'll get an office action. Let's say there's another mark that we missed somehow, because it does happen, the searches aren't perfect, where you have the same mark or it's too confusing because you're both registered in the same class. They may make you write a brief essentially saying why you should be able to use the mark, and they issue an office action, which is like its own little world that happens. So I get that a lot with people who do the legal, the document preparation services.
Okay. So I don't want to put you in a box. What is the range for small businesses that they would typically spend to register one trademark name in one class, for example? What would that process typically look like if it's, on average?
On average, a small business can expect to spend, including legal fees, between $2,000 to $3,000.
Okay.
If it's just, you're just doing the word mark, so just your name and then the one class, I have a package where it's $1,275 for everything, and then you just have to pay the fee for the USPTO, but I pay for the search, which is
okay,
$50. So
okay, so then it's you're roughly with one trademark, one classes cost $275 a piece.
Mm-hmm.
You're looking at roughly $1,500 on the low end to do that. Okay. Now, I just want to point out that if the Nike thing, for example, that's 3 different trademarks. That's not just one.
Yep, that's why it gets expensive very quickly, because if you want to do a word mark, your logo, and like a slogan, then that's where it gets more to like the 2 to even 5, depending on how many classes you're looking at, which is why I say trademarks are expensive puppies.
They are. Okay, I get it. So that's good to know. People that missed the beginning of this, Nike, which has their name, the name Nike, the swish and the logo look is a second trademark, and then the Just Do It is the third trademark. So you guys know, you can't trademark the whole package? Okay.
Well,
you have to break it apart.
It's a different application for the logo, for the word mark.
Okay.
Yeah.
Okay. Adding up. I see that. Kana, go ahead.
I work a lot with Japanese client as well. And if I wanted to have trademark, do I need one for logo, one for Japanese writing, and one for English writing? I mean, alphabetically.
Alphabetically. Well, it depends. I mean, are you marketing to Japanese clients in the US?
Mostly in Japan.
Mostly in Japan. So it may not be worth it for you unless you're getting clients in the US. We could talk about it to trademark. I think it's just, I don't think they do translations, but I can check on that. I don't fully know that. So I'd have to check on that.
Yes, I would like to know, because if I use the alphabetically written one, it may cover both. Mm-hmm. I mean, I don't expect English people to read Japanese, but the opposite might be okay. So
right.
Many companies go with alphabetically written name. So if that covers internationally, I mean, online business, we all deal with the international clients, right?
Right.
So,
but the USPTO, so my practice mainly focuses on registering in the US. So it would be, people who are marketed to in the US are typically the customers that the trademark office looks at. Okay. So Japan have its own registration system for registering. I've never run into that before.
And Nike probably has only Nike in the US. Mm-hmm. So it's not the international thing.
Nike probably has registered in every registration across the world.
Oh yeah.
They have funds.
Yeah, they've got the money. It's an expensive process to be a worldwide brand, because you've got to get on the Madrid Protocol and you've got to get on the other registries. I think China has its own registry, but I'm not sure. Again, I don't deal with the international registries.
Okay. I'm a small one-person business for now, so I also like to know, when would you encourage people to go for trademark? When you want to go step up, I think you use the term of stepping further in the beginning.
If you've got a brand and you are using that brand, you're making money off that brand, that is your name, you want people to know it's you, then we can have a discussion about trademarking that, because that's, at the end of the day, you're trademarking the brand. And if you're making money off that brand, you want to protect that source of income, right? So that's the point, when you should really let's just have a conversation about what the mark is and see if it's even trademarkable, because it may not be.
Right. Okay. One last question. Sure. Do people ever trademark their own names, like Jeff Walker or Amy Porterfield or whoever, or Doreen Virtue? Do they trademark that name?
We are seeing an uptick in celebrities trademarking their names and their kids' names. You can trademark your name. Again, it depends what your name is and whether or not it's a brand. So if you're making money off of your name as a brand, because you are like a TV personality, you've got, something coming in where it's you, then it may be worth trademarking. But for the average person, it's generally not worth it. I have a client that's currently struggling with this issue. He's got his name, which is basically tied in with a brand, and somebody else has been using, another member of his family has been using the name for a business and got to the trademark first. And there's a whole, messy thing to do with that. So it's it happens, and it depends if it's being used in commerce. I would say it depends what you're using it for.
Okay, we just have another minute. You're welcome to ask any more questions. I do want to mention though that Adrienne, you are available to work with people all over the U.S. on this topic, correct?
Correct. I can do
licensed to do federal stuff. Okay.
I'm licensed to do trademark law across the U.S., so you don't have to be based in Colorado for us to work together. But if you're looking to do a business or contract, I'm only licensed in Colorado and California. So
good to know. All right. Excellent. Any other questions before we cut? Adrienne, Luz, thank you so much for doing this. This is awesome. Great information. Really great. Thank you for coming here. Any other questions before we go?
And I was going to make an offer to those of you on the call today, and on the Mind Body Spirit Network. Usually the attorney fee is $1,275, so I'm willing to offer a special price of $1,000 for the attorney fee.
That's super generous.
Yeah,
thank you.
And so that's an offer to think about.
Awesome. Thank you, Adrienne. All right, you guys. We'll see you all again next week. Again, next week it's the ultimate website checklist. And Deborah is going to come join us. Oh, I do want to mention one other thing for Mind Body Spirit Network members. I'll send you an email, but we're doing another group book review video on March 20th, right after Deborah's presentation. So we had so much fun in the last book review one, we didn't want to get off. So it's a lot of fun. Connie, you should come join us. It's awesome. All right, you guys, have a lovely week. Deborah, can you stay on for 1 sec? And Adrienne, thank you so much.
Oh, sure. Thank you for having me. This was great.
Yeah, I'll post a blog about this and share the video, Adrienne, and send you an email with the link to all that, so you can share it as well. Awesome. Thank you.
Take care.
Hey, thanks for hosting, and thanks, Adrienne, for being here.
Claire, come again. We have lots of good stuff we share here. It's fun networking group.
Good. One of these days, I'll start making it part of my schedule.
Nice.
But if it's always on Tuesdays, I have an 8:30 a.m. workout on Tuesday.
There you go. It's Tuesdays.
Yeah. So
All right.
You might show up late more often.
That's fine. Good to see you, and late is
Yeah.
fine.
Bye-bye.
Okay, Deborah, am I going to see you this? Oh, let me stop this recording.